Predictable, stable and low. Targeting inflation to boost the economy. PBCJ committed to Jamaica and the economy. And the best way forward is using an inflation targeted strategy. Keep the rates them low, stable and intact, so consumers can buy more goods with them cash. Committed to make the economy grow. Predictable, stable and low. Inflation targeting the way to go.
Hi, Mas Errol. How you do?
Not too bad.
This was so interesting in the paper today, Mas Errol.
The EU has been doing a lot of work in Jamaica.
Who is the EU again, Mas Errol?
The European Union.
Newspaper is all well and good, but I bet I can find more information from...
How the Governor General is to act either on the recommendation of or after consultation of. If we put in anything that is inconsistent with that section, it can be seen to be an implied alteration of that section. And in any case, I don't think we would want to do something like that because the Constitution already provides how you interpret and how you understand how the Governor General must undertake his role, whether he's acting on the recommendation of someone or on the advice of someone. I don't think we should change that scheme. That's already in the Constitution. So I think as it relates to the Governor General in Council, I don't think these definitions should apply.
Do you think there's scope for them to apply it to the other areas in which advice of is used and recommendation, especially with regard to the minister?
So, and I think I'm going to ask Mrs. Seeley Brown, Parliamentary Counsel, to also speak on the issue. From a strict legal perspective, it can be done. It's just that generally we don't usually do it because you have admin law principles that explain. So there is case law that talks about what it means to act on consultation with someone and what is involved in consultation. There is also case law that talks about when you act on the advice of someone. I can't say for sure about case law in terms of recommendation, but generally these are admin law principles and we usually leave it to the admin law. But again, the only difficulty I really would have is defining it as it relates to the Governor General exercising any power. Legally, it can be done. I just don't know if it's advisable.
Just to follow up on what Mrs. Aldred is saying, there are admin principles that apply to these definitions. And I don't think it is necessary for us to define them in detail the way we have done here in this legislation. I think we should just, like how we do it in other legislation, we use the terms and then we let the administrative principles determine in what context we would, when we speak of on the advice of the context that we're speaking of it in, how we would go about determining what is meant in that context. I've never seen it done like this, and I don't know if it's necessary.
Minister, if I may, Chairman, could I suggest, if it's possible, that we look, after this meeting, look at all the areas in which this was mentioned and see how these points can be resolved, so if that would be permissible. I know that I recall that one of the circumstances when it is mentioned is the appointment of the SDG, the Senior Deputy Governor, and there could be others. So if we could just speak afterwards and come back and advise of where it is mentioned like this and what the impact would be, if that would be all right.
That's a suggestion I can take on if we agree.
Chairman, how I see it is that looking at them, they are referenced differently as they go across. And maybe I agree with the advice from the bank in terms of if they could consult with the legal team and determine as they go along how they can be treated because they are applied differently. And where it is most difficult or, challenging, we might not want to use it, as Mrs. Aldred has indicated.
Okay. All right, so that brings us back to where we left off the last time. And I'm on page, no, I have, my page is different. Page 17. And as we did the last time, I'll just read. We note that section 34 FB 13, section 34 FB 14, and section 34 FB 15 cover the conduct of the committee meetings, the keeping of the minutes of the meetings, and how the proceedings are regulated. Your committee accepts the recommendation. We note that section 34 FB 16 covers the decisions of the committee being by a majority of votes of members, and in addition to an original vote, the chairman or the person presiding shall have a casting vote in any case in which the voting is equal. Your committee accepts the recommendations. We note that section 34 FB 17 covers the remuneration of appointed members of the committee. In the deliberations, the issue was raised about the bank determining the fees or salary or honorarium without regard for the ministry responsible for finance or the public service. It was suggested that the wording of the section as proposed in the bill be amended by deleting the words "as the bank may be determined" and substituting therefore the words "as the minister may determine after consultation with the board." Your committee accepts the recommendation. We note that section 34 FC covers the secrecy of committee members and persons working on behalf of the committee regarding disclosure of non-public information in terms of the operations of the committee or the performance of its functions, save and except as may be authorized by the committee or the chairman. It was proposed that there be sanctions for breaches, as in section 34 FK2, related to the Financial Policy Committee. We know that the secrecy provisions at section 34 FK2 were related to breaches of the Financial Policy Committee members who had information in relation to licensees, and under this provision, the Financial Policy Committee members who breach secrecy may be liable to fines, unspecified imprisonment not exceeding 3 years, and this was identical to the provisions relating to the Supervisory Committee members under the Banking Services Act. We note that section 34 FD covers the indemnity of Monetary Policy Committee members, similar to the provisions of 34E of the Principal Act. Your committee accepts this recommendation. We note that section 34 FE covers the functions of the Monetary Policy Committee, which determines the monetary policy of the bank and related matters. Your committee accepts the recommendation. We note that section 34 FF addresses the setting of the inflation target, providing that the minister, after consultation with the governor, shall set the targets and speaks to the bank being required to achieve this target on a continuous basis over the medium term, defined earlier in the provision as being not less than 36 months. It provides that the minister, in setting this target, also should specify the target measure applicable for inflation and the periods for which the performance would be measured. It indicates that the inflation target was to be expressed as a range for the medium term and the target was to be reviewed by the minister. We raised concern, among other things, the bases for setting a target and whether there was need to establish the ban, particularly since there would be consultation with the governor. The implications of a framework of setting a ban, and Jamaica already operating in an inflation target currently of 46% with established benchmarks, and the necessary actions were taken when the target was missed. It was recommended that subsection 34 FF1 be worded to provide greater clarity on what is meant by the target being met on a continuous basis, how long the target is to be set for, and when it is to be reviewed. In the deliberations, it was explained that this allows for some amount of flexibility about a range, whether the range would remain for a certain specified period or not, whether it could be achieved, and how long it would take to get there. It was further recommended that it should be explicitly stated that the target measure will be as published by the Statistical Institute of Jamaica. It was also proposed that there should be an outer limit stated for the periods for the periods at which performance will be measured. The suggestion being that this should be for a period no greater than quarterly. There's also a suggestion made that consideration be given on, this is an error here, on what would obtain if at the time of the setting of the target inflation is not near, and it is therefore unlikely that the target can be reached at the time the performance is to be measured. In this regard, it should be contemplated whether language should be introduced to the effect that the target is to be met on a continuous basis after a certain date. Your committee accepts the recommendation.
So Chair, based on the foregoing, the amendments would explicitly define the target measure applicable with specific reference to the role of the Statistical Institute. And it would also set out clearly how the target is to be expressed, and in our view, as a range. Also, the period at which performance will be measured, which, as suggested, will be at most quarterly. And it would also include or specify the date from which the target is to be met, to account for the point where if a target is set at a level that's different from where the current inflation rate is, as was suggested, some account must be taken as to when that target is to be met.
There's a question. What if we take that framework? What happens between the time that announcement is made and the time that the minister specifies the target ought to be met? What is the guidance to the bank between?
The bank would then be required to set its policies. Well, you would have to agree on that the time period is feasible. And then the bank would then have to then set its policies to achieve that and communicate in explaining economic developments between that point and the desired point when the target should be achieved. The bank would have to then explain.
Okay.
Yes, through you, Chair. Yeah, my understanding of inflation targeting is that we hypothesize a particular inflation rate over the medium term, say a year, say 18 months, say 2 years. If we review every quarter, then we are reviewing our approach to that long-run target. If we are setting an inflation target within a range, then how narrow, how wide is that range? For example, 1 standard deviation, 2 standard deviation, what are the principles? Because you can set a range, say inflation is going to be between 0 and 10%. Inflation is going to be between 4 and 15%. Then that particular range does not narrow us down to the objectives that we want to achieve. So what is guiding the range that we plan to establish?
So I think the provision says that the minister on advice of. So some technical input is going to be required, and then the minister needs to table it. And the tabling of it is hopefully to guard against the scenarios that you mentioned, which would be totally less than credible. Yeah.
Chair, I want to go to 34 FK1. A member of the committee and persons working on behalf of the committee shall not disclose information regarding the performance of his functions under this part, save and except as may be authorized by the committee or by the chairman of the committee. And 2, a person who contravenes subsection 1 commits an offense and is liable on conviction in a circuit court to a fine or imprisonment for a term not exceeding 3 years, or both such fine and imprisonment. Now, as you read in the report, it was proposed that there be sanctions for breaches in sections 34 FK2. Question, are we, and this is for the legal team now, so we're proposing not only the fines, but also imprisonment. I was of the view that we're kind of moving away from that, from the double jeopardy.
So what we're doing here is exactly what is already in the bill for the supervisory committee. That's my understanding.
So what the senator is referring to is a more recent, yes, application and I think it started in 2016 in discussions at the Senate, where it was agreed that you wouldn't have both fine and imprisonment for offenses, and you would only do that where there would have been some pecuniary advantage that you then would want to remove from that person who has been found guilty of an offense. So we have been doing it in certain bills that have been coming to Parliament since that time. However, there is also another concept, which is consistency of penalties in the same act. So if you already have a similar type offense, you wouldn't want to have a different kind of penalty scheme. So the issue would be whether you'd want to amend all of them in that act, or but you need to keep them consistent. However you're going to go about it, you need to keep them consistent.
Yeah.
I'm just concerned about the consistency of it, where it is applicable in certain legislations and applied and treated differently in another one. So as you're suggesting, if we're applying it here, it ought to be consistent right throughout.
Yeah.
But it's going to come up later on, so I can tell you, when it's discussed in the Senate, that the same concern might be raised.
You know the player.
Okay. Just carrying on. We noted a concern expressed about subsection 34FF3 in terms of what was intended, and a suggestion that the target should be set and reviewed every 3 years unless the circumstances during that period had changed so fundamentally that the bank recommended to the minister that the target is reconsidered. The wrong one I'm reading. Excuse me a second. Which is the page? 20. Yeah. Yeah, 3 year. No. This one? Where was that?
Right here, sir.
All right, you can find it while I read. Unless the circumstances during the period that changed so fundamentally that the bank recommends to the minister that the target is reconsidered. It was agreed that the suggestion made should be considered, although it was accepted that the period of review of the target should be more specific than as stated in the subsection.
Chair?
Yes.
Chair, I mean, we considered this issue, and we believe that flexibility should be maintained in this clause to account for change in circumstances. And that's particularly important in Jamaica's context, where the Jamaican economy is actually in transition in light of the various reforms that we have been implementing. And therefore, we believe that it would be appropriate to actually maintain the flexibility as suggested in the draft bill.
Yeah, no, so the bank is suggesting what we had discussed was the concept of the target being reviewed at a specific period. And that, you want to just repeat what you said?
So the suggestion was that we should actually insert a specific period. And we would advise against this because I think in Jamaica's circumstances, particularly in a context where the economy itself is undergoing significant change, we should maintain the flexibility.
Through you, Chair. What is the purpose of reviewing the target every 3 years? As opposed to reviewing it every 2 years, or reviewing it with a political cycle every 4 years or 5 years, then so to speak? What's the objective?
The Chair, member, the 3 years was actually a suggestion by a member of the committee.
So we're saying on reflection, we would lose more by having a fixed period for review. There has to be the flexibility to review whenever it may deem necessary, recognizing that could be abused, right? But the whole point, the check against abuse, is that if you review it, you have to table it in Parliament. So that should guard against, nothing is foolproof, but it should guard against, an abuse of the system.
Minister, if I may just add a thought, that at the section as currently worded already has some checks and balances, because in there it already says that at the time of setting this target, the target shall be reviewed by the minister at such periods as may be determined by him after consultation with the governor at the time of providing the target. So from this stage up front, persons would know what period the target is going to be reviewed, and it's not, as I understand it, a matter that would be arbitrarily implied.
So basically,
so it's already in there. It's just that what this, sorry.
Yes.
So what this is not doing is indicating what that period is, and I think that Deputy Governor is saying that circumstances may be such that that period could be X or Y. This is my understanding.
Chairman, again, we're trying to model this off other places. What is this Canadian situation, or what's the UK situation in terms of
Canada reviews its targets every 5 years. But in the Canadian situation, the Canadian economy is a very stable economy. Not a lot of variation in inflation. So it's understandable that you can have a target that holds for an extended period of time.
Last time I heard the Minister of Finance spoke, he spoke about trying to have a stable economy. And so that we aspire for what Canada as well. And we shouldn't predicate our planning process on instability. So I am for a set period. We know if we achieve something along the way. But when we have no period that is set, and then the whims and fancy, as you indicate, Minister, abuse, you said, can intervene. And I want us to be guided by some signposts.
Mr. Chairman?
Yes. Hi, I should have welcomed you when you came.
Perhaps a compromise could be the original language, but just adding a sentence saying, but not later than 3 years.
Agreed, Minister. But I think we'd probably have to have a discussion as to since we're setting a kind of outer time limit, what would be an appropriate time frame?
I can live with that. Yeah. Thank you. All right, let's continue. We note that Section 34FF4 covers the publication of the notification of the inflation target once it was set on the website of the Bank of Jamaica. In relation to Section 34FF4, it was also recommended during the deliberations that given that it was the government's inflation target for which it was accountable to the people, The section should also provide that a minister should cause the target to be published on the Ministry of Finance's website. Your committee accepts the recommendation. We note that section 34 FF5 provides that, even though accountability is really the central bank, but when we really get going, but I understand that's a transition. We note that section 34 FF5 provides that in the event that the target was missed, the bank must notify the minister within 60 days. This would include the reasons for the missed target and the proposed actions. Under section 34 FF6, the minister was required to table a copy of this notification before Parliament. It was suggested in the deliberations that in the furtherance of democratic transparency and good governance, a provision should be added to section 34 FF requiring that the inflation target, once set by the minister, shall be tabled in the House of Representatives so that it can be debated. The bank indicated its agreement with that proposal, as it was expected that at the time when the Parliament was considering the fiscal policy paper, which sets out the government's economic objectives, of which inflation target was a critical component, the debate on the target would be in that context. Your committee accepts the recommendation and further recommends that a provision be added at section 34 FF to address that inflation, once set by the minister, shall be tabled in the House of Representatives. Just something from, sorry, go ahead.
Sorry, Minister, just for completeness, could you say inflation target, just to be crystal clear?
Inflation target, that's fine. But on this point here, I agree with the tabling of the target. A political debate or a partisan debate around the target is not. I don't think that is.
Find out, Chair, what is the objective of having a debate?
I don't think we should have a. I think that what was intended was to say that you need transparency. Yes. You can't just in the dead of night set the target and don't tell anybody. You need to come to Parliament and table a target.
Right.
But the idea was not to have a debate. That is.
So table and have
the
Parliament pass.
They can ask questions.
Right.
They can ask questions and so.
I am not sure in my mind if is the debate going to seek to change what has been proposed? So
exactly.
Why is there the need to have a debate?
I think it's tabling, and once it is tabled, you can ask questions. You can ask questions now, you know. Anybody can ask questions now.
Or seek clarity.
Or seek clarity, no. But tabling it is just a higher act of transparency.
Look, through your chair, look at it this way. Would the debate provide a reasonable check and balance as to a publicly expressed rationale for why the target is set at this particular rate?
I would say the questions and the clarity being sought would provide that.
Okay,
so it's a subtle difference between saying you table it and people can do what they want. Today,
I mean the debate, the participants in the debate won't have the technical expertise anyway to say whether or not the particular rate is X or Y. So, I mean.
Yeah, so tabling it is what we had agreed to. And
Chairman,
yes, sir.
The report says tabled so that it can be debated. The standing order of the House now, as I understand it, is that announcement and these things are tabled. You're not even allowed to ask questions at that stage. So it would appear to me if questions is to be allowed, that's further down in the agenda at question time, which requires submitting questions and waiting 21 days or more. And that doesn't seem to be what we want for this important issue of economic policy, at what level the target is. With the fiscal policy papers now, I've never read, except out of the budget debate, a discussion on the fiscal policy paper. But the purpose of it is not just to lay it there for information, but to guide and govern policies. So I'd be of the view that a mechanism needs to be found in the standing order where some time is allowed for this, so that it may come under statements from minister, which is where you allow questions and comment, brief though they may be. So it is where if you're going to make this a table, it's just file 13. If it's going to be a statement from minister that accompanies it, it then allows for that interaction, which I think is necessary. And I will say this, even though the parliamentarians are non-technical people, they are subject to be advised. And therefore, the citizens need to get a sense of, some of them technical to cover, but so the citizens can get a sense from that discourse in the parliament of what is up. Otherwise, we're fooling ourselves.
No, but I hear you, Senator. I would strongly prefer that we just leave it at the tabling. You know, in other jurisdictions, the setting of the target is not even in the political realm. The setting of the target is with the bank. Mm-hmm. If we make this if we put something in place that incentivizes a partisan stuff around the setting of the target, then we're just going to hasten the day when people are going to be calling for the target to be taken out of the political realm and put into the bank. We had discussed it, and we had arrived at tabling it. I just raised it here because
Minister, unless the report before us is wrong, the report speaks about table so that it can be debated. I don't think the Secretary inserted that in it, but for the deliberation of the committee, so that we deliberated on that, and we felt that it is, I believe we can rise above the partisan politics, but the citizens need to have an interrogation of our economic policy. It can't be just reserved for ministers and governors. It must involve the people and the people's representative. And this is mainly in the House.
I'm saying debate is I'm just suggesting.
No, but I made a suggestion now, that the standing order should find it under, the minister makes a statement and table it, but the ministerial statement allow for question and exchange.
Well, Mr. Chairman,
that's where it needs to go.
I tend to want to go a little further than my colleague from the Senate. I think it should be in the form of an affirmative resolution, and let that resolution be debated. If this is such a fundamental economic target, and once established, it's going to be there for years, what is wrong with having a debate on it? I mean, is it that we hold each other in such contempt that we don't believe that we can have a reasoned debate about it, even if we don't agree? What risk is there from having a debate? What risk is there from coming to the Parliament and through the Parliament to the public and justifying the basis for the decision? I mean, you know, that seems to be deepening our democracy. And just as we, in some instances, say we need different rules from other economies that are more stable, we have been pioneers in other elements of economic management. What is the name of it? The oversight, EPOC. We were pioneers in that. So I am not, shackled necessarily by what takes place in other jurisdictions. Other jurisdictions would have had their own particular history. But I see nothing other than an opportunity to deepen our democracy, our understanding of economic policy, by having an affirmative resolution. Just needs a simple majority to pass. It doesn't mean that the opposition gets any veto over any policy that the government sets. It's going to be there, having been set for maybe 3 years, unless something unforeseen turns up. I don't see what's wrong with having it tabled via affirmative resolution so that it can be debated, as the report says.
Okay, I'm strongly against that, Mama Bunting. And I will explain by reference to something on this committee itself. Whenever things enter the political realm, right, in which many factors are at play, sometimes incentive exists, the political incentive exists to express one's dissatisfaction on something totally unrelated. And we can't afford that here. A statement by minister, what Senator Brown is speaking about, in which there are questions that are asked, I think can be accommodated. But you recall the second or third meeting of this committee where you walked out because you had a disagreement over how the government was handling Petrojam? That's what happens when you put this stuff in the political realm, right? You get extraneous, you get extraneous political action, and we can't afford that with respect to a technical matter such as this. So we strongly recommend that the inflation target, once it is advised by the central bank, it is set, it is tabled, and if we want to go, on reflection, if we want to go and say, because my read or understanding of the intention, and something that I would be very open to, is that once it is tabled, questions can be put and those questions answered. And if the form in which it takes is as suggested by Senator Brown, that I think works. But having a debate and affirmative resolution goes way outside of the policy intent.
Minister, I believe that meeting in December at BOJ resulted in the PAC finally taking up the issues, which was good for the society. But that notwithstanding, this committee has demonstrated the capacity of parliamentarians. No. This committee, constituting each of the individuals, have demonstrated our capacity to put the national policies above partisan concerns. I think it would be fair to say that this committee and the work we have done along the way has demonstrated that, cooperating with the technical people, cooperating with the Bank of Jamaica, and sometimes we beat up ourselves that we are negative when all we're doing is trying to get a better outcome. So in this, whether it is the suggestion of Member Bunting or my suggestion, the concern I have is that, and we must bear in mind, we are going to be in opposition one day. We are going to be in government one day. So we need to set the policy bearing in mind what would be good, whichever side we sit on, whether over there or over here. And I believe the people of the country, everything that BOJ is going to do is henceforth is going to be predicated on the inflation target. So the people need to know, or will they know, by being part of the discussion, by hearing people saying, maybe we should up the target, maybe we should keep the target down. Right now people are saying, why are we at 4 to 6? Well, for the last so many years we have been below 4. At least that discourse could take place, divide a partisan thing. And if a little partisan thing come into it, give thanks that there are people like Lindsey Graham who has no consistency alive in the politics. That's all it will show.
So I'm going to just use in Chairman's prerogative and suggest the compromise that when we say it's tabled, we explained table to mean, in the statement by ministers, which automatically opens up that tabling to questions and for a back and forth and a discussion and explanation and so forth.
Administratively, Minister, if we take that route, I would expect that a statement by minister would be accompanied by sharing with the other side, whichever side is, at the end of the day, the documentation.
When we're in power, absolutely. I hope that's the case when you are.
Well, I'm sure Peter Bunting can speak for Mark Golding. When we are in power, we'll take the same approach.
Okay. No, so the committee would want it to read that when we say tabling in Parliament, we mean tabling in the form of a statement by the minister. And the reason is that's an avenue by which the tabling would be subject to immediate, questions and back and forth and explanations and so forth. Okay, in relation to section 34 FG2, it was suggested that consideration be given to rewording the section as the two references to 6 months so closely following each other seemed awkward. In relation to section 34 FG3, concern was expressed about the period of 6 weeks to publish the minutes which appeared too long. The committee suggested that the time period for publication of the minutes be re-examined, having regard also to precedents of the central banks in other jurisdictions. Your committee accepts the recommendation, but we never came back with a time.
Chairman.
Yeah.
So, Bank of Jamaica wants to suggest that we'd work with the 4 weeks, bearing in mind especially that we'll be publishing the same day or the next day. What is the decision of the committee? So you get the decision immediately, and within 4 weeks you get the opinions of the members.
I think that's...
What was the publication of the same day?
The decision.
The decision.
Yeah. The decision.
Okay.
Okay.
Remind me, I'm kind of recalling, was there a shorter period in the other jurisdictions? I know they're well advanced, but I'm just trying to compare.
Yeah, Chair, it ranges, it's a wide range from 10 days. You have jurisdiction that has 10 days, 2 weeks, 4 weeks, 6 weeks, 8 weeks.
Okay. Your committee notes that the bill introduces... Can I take it that the committee agreed to the 4 weeks as the compromise? BOJ had insisted on the 6 weeks for a long time. Yeah, thank you. Your committee notes that the bill introduces a new part VAB, to deal with the Financial Policy Committee and covered section 34FH to section 34FL. Your committee notes that section 34FH addresses the definition of committee and accepts the recommendation. We agree that in respect of the definition of government company, this should be treated as with the case of the definition of government company under part VAA, in bracket section 34FA, with respect to the Monetary Policy Committee, and removed from this section and included in section 2 of the Principal Act. Your committee notes that section 34FI addresses the establishment and composition of the Financial Policy Committee. Your committee noted the proposal for 4 ex officio members and 2 appointed members of the bank, and decided to accept the recommendations for section 34FI 1 to 3, save and accept that for section 34FIC, it was agreed that this was to be amended to take account of a scenario where the senior executive mentioned in this paragraph was the governor, senior deputy governor, or deputy supervisor, then there should be a proviso that this should be such other senior executive determined by the board. Your committee notes that section 34 FI4 and 34 FI5 addresses the appointment of members of the Financial Policy Committee, the eligibility requirements for the Financial Policy Committee members, and it includes fit and proper criteria and qualification. Your committee accepts the recommendations. We also recommend that banking and law be added at subsection 34 FI5C. Your committee notes that section 34 FI6 addresses persons who are ineligible for appointment to the Financial Policy Committee and is identical to the provision relating to the Monetary Policy Committee. During the deliberations, it was proposed that, as with the case of the section relating to the Monetary Policy Committee at subsection 34 FI6A, it be amended to read, appointed members of the board or statutory committees of the bank, and for subsection 34 FI6E to be amended by adding the expression agreed under the Monetary Policy Committee or a partner or employee of the external auditor of a financial institution. Your committee accepts the recommendation.
Chair, recall that in relation to the Monetary Policy Committee, the section was amended by the recommendation was made for the amendment. So it would read instead, appointed members of the board or other statutory committee of the bank, save and except for a person who is only on one other statutory committee, and accordingly no person would be on more than 2 statutory committees at any given time. So that would be in keeping with the amendment that was proposed for the Monetary Policy Committee.
Okay. Your committee notes that section 34 FI7 and section 34 FI8 relate to the term of appointment to the Financial Policy Committee with members being eligible for reappointment.
Can I just ask there, so in order to ensure continuity, is there a timeline in which such reappointment or the appointment of the new member can be established?
No, I don't understand what you're asking.
All right, so they are up for reappointment. So you want to ensure there has to be a period where you cease to exist because you now would be at the end of your tenure. So is there a timeline for the reappointment so that there's no vacuum between the period of you a member exiting and the reappointment?
I mean, it is like any other position with a term, right? The term comes to an end at a particular date. If you are, depending on the organization level, you can be in a position that there's no vacancy. I don't know if we can, by statute, provide for that.
I think the point that the section wants to make is that having finished a term, you are eligible for reappointment. Now, of course, one hopefully would have had those conversations before, and gaps can happen and do happen. But I think the only thing this particular provision wants to make, point it wants to make, is that any member who serves can and is eligible for serving again. But there could be gaps, but the section wouldn't be able to address that. Hopefully the conversations for a reappointment would happen before, and so there would be continuity.
We note, your committee notes that section 34 FI9 covers the revocation of the appointment of members being by the Governor General in Council and the reasons therefore. As with the case of the provision relating to the Monetary Policy Committee, it was agreed that the revocation of appointment should be by the Governor General in Council on the recommendation of the board. Your committee notes that for section 34 FI9, there was a proposal to substitute the letter D for the letter E following the letter C. Your committee accepts the recommendation. Your committee notes that Section 34 FI 10 covers the publication of the names of all members of the committee in the Gazette as first constituted and any change in the membership of the committee. Your committee accepts the recommendation. Your committee notes that Section 34I11 covers meeting frequency to be determined by the Financial Policy Committee. Your committee recommended that there be a stated minimum number of Financial Policy Committee meetings per year rather than leaving it unspecified. This was supported by the bank. It was suggested that the words not less than 4 times per year be inserted after the word meet. Your committee accepted the recommendation. Your committee notes that Section 34 FI 12 addresses the assignment of staff, including a secretary, to assist the Financial Policy Committee in the performance of its functions. Your committee accepts the recommendation. Your committee notes that Section 34 FI 13, Section 34 FI 14, Section 34 FI 15, and Section 34 FI 16 were identical to the Monetary Policy Committee provisions regarding chairmanship of the Financial Policy Committee. 13. Casting vote of chairman, which was subsection 15, the committee regulating its own proceedings, and the keeping of minutes. Your committee accepts the recommendation. Your committee notes that Section 34 FI 17 is identical to the Monetary Policy Committee and addresses remuneration payable to appointed members of the Financial Policy Committee. Your committee did not accept the recommendation as worded, but recommends substituting the words "the minister may determine after consultation with the board" for the words "the bank may determine." Your committee notes that Section 34 FJ addresses the protection of members of the Financial Policy Committee and agreed that the provisions for indemnity of members of the Financial Policy Committee would be the same as the Monetary Policy Committee. It was agreed that the provision as worded should be deleted and the provision as in Section 34 FD, which follows Section 34E of the Principal Act, be substituted, as was the case for the Monetary Policy Committee. Your committee accepts the recommendation. Your committee noted that Section 34 FK addresses secrecy requirements of the committee members. Your committee accepts the recommendation. Your committee notes that Section 34 FLA addresses the functions of the Financial Policy Committee, including policies that govern the conduct and promote the proper functioning of the financial system and the matters set out at paragraphs 1 to 5, and agrees that it should be treated as a policy committee. Your committee accepts the recommendation. Your committee also notes the committee's responsibility for the determination of the matters set out at subsection 34 FLB, which are policy-making functions that are presently addressed by the Supervisory Committee under Section 7, 1H and M of the Banking Services Act. Your committee accepts the recommendation. Your committee notes that Section 16A amends Section 34MB of the Act, found in the 2015 amendment, which addresses emergency liquidity assistance to financial institutions and collateral policy in that regard in the event of or in anticipation of threats to the financial system stability. Clause 16A seeks to insert the words "notwithstanding Section 23F" before the word "make." In the deliberations, your committee noted that loans to financial institutions promote stability in the financial system, that loans to financial institutions to promote stability in the financial system are not subject to the restrictions of Section 23F, which addresses temporary advances to financial institutions under 6 months. It distinguishes the extension of credit for financial stability purposes from the normal advances to financial institutions. Your committee agrees with the recommendation. Your committee notes further that Clause 16B, which amends Section 34MD of the Act, provides that the Bank of Jamaica may provide emergency liquidity assistance to financial institutions subject to the provisos set out at paragraphs 1 to 5. The proposed new section limits the bank in the provision of emergency assistance unless the financial institution has demonstrated that it has failed to access loans from the financial market, or in the opinion of the bank, the financial institution is likely to fail in so doing. 2, the financial institution will be charged interest on the loan or advance at a rate to be determined. And 3, any discount which may be applied by the bank to collateral provided by the financial institution in relation to the loan or advance shall take into account the bank's determination of the risk of the collateral losing value and the amount of such loss during the life of the loan or advance. Remedial measures as agreed by the bank are adopted and approved by the board of directors of the financial institution to strengthen its financial viability, and the financial institution is solvent. In the discussion, it was suggested that consideration be given to amending paragraph I to provide instead that the bank is satisfied that the financial institution has made efforts and failed to access loans from the financial market. The BOJ would consider the amendment of that provision.
And Chair, we did and we agree. We're comfortable with the amendment, proposed amendment.
Okay. Your committee members referred to subsection 34MD Roman numeral 4 above on the remedial measures, noting that such measure often took weeks of back and forth between the central bank and the institution and the boards. It was suggested that there be an amendment to subsection 34MD4 to read remedial measures agreed by the bank are approved by the board. Well, we just read that, right? That's what we just read. However, some members stated that remedial measures to be contemplated must be identified and agreed in order to get the liquidity assistance. If those measures were not implemented, they would be breaching the undertaking, which would then trigger other action to be taken by the bank in its supervisory role. During the deliberations, it was suggested to amend subsection 34MD4 to provide that the board of directors of the financial institution has undertaken to implement such remedial measures agreed by the bank to strengthen its financial viability. Well, this is a repeat of what we just read. The BOJ would consider the amendment of this provision, and you just confirmed that you have considered it and you're okay with it. Can you speak into the mic?
Yes, Chairman.
Okay, thank you. With respect to subsection...
Just for clarity, Mr. Chairman, the BOJ will accept this specific wording as is.
Yeah, the amended.
Yes, Chair.
With respect to subsection 34MD4, we noted the suggestion that the undefined term solvent should be defined as the financial institution's assets exceeding its liabilities. Your committee accepts the recommendation.
Chair, just a correction of the subsection to 5. That particular one is 5. Yes, that's a typo.
Thank you. Your committee notes that Clause 17 amends Section 36 of the Act and provides that the bank, in any fiscal year in which there occurs an event declared by the Prime Minister to be a national emergency, may make temporary advances to the government under certain conditions, including that such advances should not cumulatively exceed 5% of the average of the recurrent revenue of Jamaica for the 3 fiscal years preceding the year in which the advances are made. That interest will be charged at market rates, that repayment should take place no later than 4 months after the end of the fiscal year in which advances are made, and that no further advances would be made in any subsequent fiscal year until the outstanding advances have been repaid. Subsequent to the deliberations, your committee accepts the recommendation on the basis that the minister must be of the view that there is a national emergency which would impact the revenues of the country, and subject to the approval of a resolution by the House of Representatives for an advance to the government. It was agreed that the wording of Section 36(1) be amended to provide that such advances could be made to the government in an event of national emergency based on a submission tabled by the Minister and approved by resolution adopted by Parliament. With regard to Section 36(1)(c), some members expressed concern regarding Section 36(1)(c), which provided for the repayment of the advance in cash or with marketable securities, noting that if payment was made with marketable securities, it would be termed out debt. This was not in the existing Act and was seeking to reintroduce flexibility when the regime had been moving more rigidly and making it more difficult for rogue persons who were in positions of influence. Your committee recommends the removal of the words "or with marketable securities" after the words "made with cash," unless the bank could provide a rationale for why the words should be retained.
Chair, after careful consideration, we recommend that the word marketable securities remain. The challenge we foresee if it's removed is that whenever the government pays cash into the bank, it affects liquidity condition in the economy, which we may not want, which may not be appropriate at that time. And therefore we think it's better to maintain it. We, however, would suggest that we could include after the phrase either in cash or with marketable securities as determined by the minister after consultation with the governor, since this is an issue that will affect the debt stock.
Yeah, I mean we've seen that play out time and time again in Jamaica, where when you move cash, the cash is coming from somewhere, so it affects liquidity, whereas securities won't affect the liquidity, and the bank monetary policy uses interest rates and liquidity to influence conditions. So that is what we're struggling with here.
I think if I recall, this was some time ago, but if I recall, the mischief that we were trying to correct was something that had actually happened in the past, where the government had issued some zero coupon bonds to satisfy some debt, and it was felt important. I think the point that we're making here is that it should be real securities that had a meaningful, something that would be accepted generally in the market, not just a convenience for the government to say that they had placed something there. So perhaps if some definition or something about bearing a market interest rate, for example.
So, Chair, elsewhere, I mean, we had defined marketable securities to reflect
to address that.
Yes.
Okay.
For that precise reason.
Okay.
Yeah.
And the paragraph above, subsequent to the deliberations, your committee accepts the recommendation. Again, just due to the passage of time, I'm just trying to get it clear in my own mind now that we have removed the Prime Minister from this declaration, and it will be something more akin to a state of emergency, but that resolution will be brought by the Minister of Finance, and it will require a majority of the House of Representatives to
That's correct.
for it to go forward.
That's correct. In the deliberations, it was recommended that the phrase "in any subsequent fiscal year" be removed from section 36(2)(b), which would clarify the intent that no further advances would be granted unless and until the outstanding balance advances had been repaid. Your committee accepts the recommendation. Your committee was advised that Clause 18 amends Section 37 of the Principal Act and addresses the limitation on the power of the bank to purchase securities issued or guaranteed by the government. Your committee accepts the recommendation subject to the following: that there be a definition of secondary market transaction as a transaction in securities that have been fully paid up for cash in an unrelated prior transaction. Unrelated prior transaction to be defined for this purpose as meaning a prior transaction which is not effected in contemplation of a subsequent sale of securities to the bank. 3. Primary issue to be defined as including any issuance of securities which is not a secondary market transaction. 4. Under subsection 37(2), for clarity, there should be listed as paragraphs A to D the 4 stated purposes for which the Bank of Jamaica can purchase Government of Jamaica issued or Government of Jamaica guaranteed securities on the secondary market. We should have here, you have it at the top. Your committee accepts the recommendation subject to the inclusion of the following. That's what you really should read, right? Your committee notes that Clause 19 addresses the power of the minister to give general direction and sought to amend Section 41 of the Act to specify that while the minister may give to the Bank of Jamaica directions of a general nature that to the minister appeared necessary in the public interest after consultation with the governor, the minister may not issue to the bank directions on monetary policy or supervisory matters pursuant to the Banking Services Act. In the deliberations, your committee asked what was included in the expression monetary policy, and in particular, whether this included, for example, in relation to foreign exchange. It was added that the province of what was excluded in terms of the boundaries, etc., might be contentious unless there was clarity in the area. It was agreed that consideration be given to a definition of monetary policy to provide clarity on the boundaries, particularly with regard to whether this would include actions related to foreign exchange market, and the chairman indicated he would consult on the matter.
Chair, to address the point raised, the bank is suggesting an amendment of section 412 of the bill to read, notwithstanding subsection 1, the minister shall not issue to the bank directions in relation to monetary policy, and as a clarification, purchases and sales by the bank of foreign exchange, decisions to increase or reduce external reserves, the management of external reserves, or supervisory matter. Here we wanted, given the concern about the boundaries, here we wanted to make clear that it would exclude any action that would affect monetary policy.
Just for clarity, Mr. Chairman, this new wording that was just presented there, the Bank of Jamaica would have independence in establishing the level of monetary reserves and how the levels at which they set it, not monetary, sorry, international reserves. So the NIR is a figure that would be totally determined by the Bank of Jamaica, the levels and how they use it to intervene in the foreign exchange market. I just want to establish that's what you're seeking to specify in the amendment you just described.
Right, and this is in a context where changes in the reserves will affect monetary conditions, monetary aggregates, and hence monetary policy. So we need to ensure that they're all consistent.
When you sell reserves, you take Jamaican dollars out, so you're affecting J dollar liquidity.
Right, I understand that. But as you build international reserves, does that not have a fiscal implication? You're purchasing it with Jamaican dollars.
I mean, the bank's operations, yeah, there's a fiscal implication in the sense that if the bank makes a loss, it is on the fiscal accounts. If the bank makes a profit, there's a dividend to the government.
Yeah, I guess it just comes back to a fundamental thing I have is if the Minister of Finance ultimately is going to have to write the check, can all these actions, I understand operationally, but the longer term ones like setting the levels of the international reserves, should those be completely autonomous?
Yeah, well, autonomous is, yes, by the central bank, yes. I mean, the central bank, in pursuing an inflation target, has to be concerned with the levels of liquidity in the Jamaican system. It also, though, has to be concerned with the maintenance of external sustainability. And having, every year, all members of the IMF, all 189, have their reserves assessed for adequacy by the IMF, and those things are published. And they have to, has always been in the central bank's domain. Yeah?
No, I understand, but let us say the IMF assesses $3 billion as adequate. We decide we want 6 or we want 9. We want 3 times what is assessed as adequate. That is totally left to the discretion of the Bank of Jamaica.
Well, it's constrained by, just to answer your question, painting a ridiculous scenario, it's constrained by the inflation target. If a central bank were to try to pursue 9 when 3 is sufficient, then it would completely mash up the inflation target. Yeah, it would be, it would completely mash it up, so to speak, to use a colloquial expression. I mean, I'm not so comfortable with the definition of monetary, because I don't want to run the risk of constraining unnecessarily constraining. Just repeat what you had said, like your suggestion.
Right. So it would be the minister shall not issue to the bank directions in relation to monetary policy, purchase and sales by the bank of foreign exchange, so on and so forth.
In addition, okay. Okay.
Coming back to the other aspect of this repeal of the section 41, where the minister also may not issue directions on supervisory matters pursuant to the Banking Services Act. This, again, I just given our history in the last 30 years, or given the US history in the last 15 years, where you have a banking crisis, is it that there is no role for the Minister of Finance at all?
Well, the central bank will always have to have a close working relationship with the Ministry of Finance at all levels, and particularly between the Minister of Finance and the Governor. What these mean is that the relationship should not be one of undue influence, right? That you can't write to the Governor and say, you must do this. But the relationship, as in any country, you have to have it's by definition, what the Ministry of Finance does has an impact on what the central bank, on its operations. So you have to work together. All this is saying is that the central bank, at the end of the day, with supervisory matters, instruction that could be politically motivated or otherwise can't come from the minister. Now, remember, this is already in place. This was put in, the supervisory part of it was put in place in 2014, or was it 2015? One of the two. And so far, it's worked. We've gotten.
No, and I agree operationally. So in terms of supervising individual institutions on a normal basis, this is perfect and appropriate. I'm just saying when there's a systemic or threatened with a systemic collapse, whether a minister just becomes a spectator or the government becomes spectators and watches the Bank of Jamaica attempt to manage the systemic collapse.
What God forbid. God forbid. But what I'd say to that, member, is just, I guess, to emphasize what I was saying earlier. The relationship between the central bank and the Ministry of Finance in any administration, has to be one of a working relationship. And God forbid if there were something like that. Well, we now have the facility where the central bank has to report to Parliament on a regular basis. So not only would the minister get involved in a situation like you're describing, the Parliament would be involved. What we're doing here is increasing and elevating the levels of transparency and accountability, making it more transparent, more accountable. So the questions that the governor of the central bank, who is a leader of the bank, would face are not going to be just questions between the Ministry of Finance. They're going to be questions in here as well.
Chair, just to add that the Financial System Stability Committee includes on that committee the financial secretary. So in the event of a systemic crisis, there is a role for which fiscal concerns are taken on board.
God forbid. Your committee notes, and just for your member, this is outside the scope of this committee, but we're working on a special resolution regime that should come hopefully another year from now, which is going to be a bankruptcy provision for the financial institutions. So if we are ever to go through, the idea is that banking failure does not become systemic. There's a way of going in and cauterizing. Right now, the Bankruptcy Act that we both worked on a couple of years ago on a Joint Select Committee is the only bankruptcy act we have for the entire private sector. We're going to come with a regime just for financial institution, and that is specific for financial institution. An idea there is to, by a lot of measures that are going to be included, to try our best to ensure that bank failure does not necessarily mean, that the entire system goes down.
And coming back to the earlier point that we had made is that solvency, bank failures, bank insolvencies usually start with illiquidity, and then rapidly, when they're having to keep selling. So, comes back to one of the earlier points that we are amending here.
No, absolutely, and that one is I can see that we're going to have a deep policy dive on that piece of legislation when it comes. It's very, very dense and very serious matters to consider as to who should really bear the cost, right? The apportioning of cost between shareholders, depositors, and so on, and something that I hope we'll get here pretty soon. Okay, moving on. Your committee notes.
The intention is for banks or for broader financial institution. I have in mind the headline in the Gleaner today.
For the special,
yes.
The special resolution regime.
Yeah.
It's going to be for it's broad, it's systemic, financial institutions,
including insurance companies.
Yes. Yes. Your committee notes that Clause 20 amends Section 43 of the Act, which addresses the accounts of the bank and audits. The changes fell under one of two categories. One, changes to align the provisions in this law with the Public Bodies Management and Accountability Act, or two, changes related to the entrenching the independence of the central bank. It seeks to, among other things, ensure reference to the accounts being prepared in accordance with the generally accepted accounting principles specified by the Institute of Chartered Accountants of Jamaica, in keeping with Section 3 of the Public Bodies Management and Accountability Act. Some concern was expressed that the new Section 43 was inadequate without being supported by the robust accountability architecture in the PBMA. And members were assured that the regulations would capture all the relevant aspects of the PBMA and would be attached as a schedule. It was suggested that at subsection 43.5, it should be provided that the Auditor General should examine the accounts and other records of the bank instead of in relation to the bank, and your committee accepts the recommendation. Now, we do have a draft of a fairly advanced draft of the regulations, which I'm going to be asked to be copied and shared. You got it, right. The purpose here is not to discuss this today, but for you to have it for your perusal. There are a few further amendments that the central bank had suggested that will be incorporated in a subsequent draft that you will receive. But the purpose here is just to demonstrate that the committee's recommendation has been taken on board, and the regulations will be submitted at the time of the bill's return to Parliament. So we can discuss the regulations at another time. Moving on to Clause 21. Your committee notes that Clause 21 amends Section 44 of the Act regarding the main activities of the Board and committees of the Board. It provides that the Minister tables a report before the Parliament and for the Governor to present the report to the House of Representatives and answer questions in relation hereto. In terms of the timeline for the report to be laid and presentation made by the Governor to the House of Representatives, members were advised that it would be as soon as practicable after the Minister was in receipt, that is, within 90 days after the end of each financial year. It was suggested that it should be clear that the presentation should be required to be made by the Governor with dispatch. However, it was suggested that practically this should be done by way of standing orders, which would be addressed other than by way of the bill, unless based on the advice of the Solicitor General and Attorney General, this could be provided for by way of the Act. It was also suggested that consideration be given to rewording subsection 44.2a for clarity to break this into two subsections. The first subsection would end immediately after the word Senate, And the second would read, the governor shall present the report to the House as may be required.
Going back to the first paragraph, as the Solgen and the AG giving us a view, I'm looking at the last sentence in that paragraph.
Deputy Governor Roper, you going to come in on this?
Really
No, I know. I'm going to ask him first and then give them some time to respond.
Well, Chair, the comment we had in relation to the second part of the item, we agree with that construction. I can't speak for the Solicitor General and the AG, so they would have to answer that first part in relation to the changes. But we are we're okay with the construction of the revised clause, having an A and a B.
All right, wait the Solicitor General when they're finished.
Sorry, I hadn't seen this part of the report, so I am not prepared to answer today, except to say that I don't believe it's addressed no, and would need an amendment to standing orders. I don't know that it can be accommodated with the current standing orders.
I'm thinking, wouldn't that be a committee of the Parliament rather than standing the governor standing before the House of Representatives to present a report?
It will be standing Finance Committee.
That's what I'm thinking. It'll have to be rather than because it says a House of Representatives.
Yeah, but the Standing Finance Committee is a committee of the whole House.
Yes, but it will have to say that rather than the House of. It can't say it like it's written here. It's not correct.
Okay, that's what we intend. Standing Finance Committee. So can we have that amendment made?
Chairman, sorry, Chairman, I see the requirement for advice from the Soldier and the Attorney General. Is there, apart from the nomenclature, is it one chamber or is it separate chambers?
It would have been advice from the Attorney General or the Attorney General's chambers.
Yeah. And that includes the Solicitor General. And that includes the Solicitor General.
Yes, the Solicitor General acts as that the Solicitor General is the assistant to the Attorney General.
I know it is because of what is written here.
But have we come? So are we going to leave this to come back to it?
Well, we're saying that I don't know if we can amend the standing orders through the bill.
No, I just think we should put it in the law. So include it in the bill that it is required by law that this take place. Now, one way of doing it is use the bill to amend standing orders.
Right.
But standing orders can always be amended without coming back to law. There's a committee of the House that can amend the standing orders.
So we can recommend that happen.
Right. So the law could amend it now, and it could be reversed by the Standing Orders Committee.
I just wanted to point out that there is a precedent in the Integrity Commission Act that the Act amended standing orders. However, there is a view, not a view I share, but there is a view that it wasn't appropriate and that it really should have been done by the Standing Orders Committee, that you would have Standing Orders Committee sit and discuss and deliberate and then...
Can you give us your recommendation here? Just guide.
Why not have it a way that the recommendation comes from here and the Standing Orders Committee makes the changes? Because the recommendation have to come from somewhere. They're not going to just take it up among themselves to make that determination.
Please, with respect, standing orders can be changed anytime by the recommendation from the Standing Orders Committee. Even though whether or not it can be changed by a bill, amending the standing orders, but then it doesn't have to come back. It doesn't require an act of Parliament to reverse that. It's just the Standing Orders Committee making that adjustment. So what I'm saying is, if it's the intention that this is permanent, and we want this to be part, to be compulsory, then we should put it in the law. And I don't.
You're advocating amending the standing order through the bill.
No, I'm advocating that
we should make a recommendation.
A requirement in the bill, which will put it in law, so that it's not that easily changed unless you're going to amend the law.
So, sorry, may I just ask this, Chair? I think at section 2A, the concern had been that, as worded, it is saying that the minister lays the report before the House and the governor shall present the report. And I think the concern of the members was that the governor should do that with dispatch. So, and hence the discussion. So suppose we simply said with dispatch subject to the standing orders or whatever phrase there would be, because as we had mentioned the last time, the governor can't just get up and say, well, I have to do this with dispatch, and so I'm going to do it today. So if we said with dispatch subject to the standing orders, would that work, or some wording like that, or what would be the equivalent?
I think we can speak to the Standing Orders Finance Committee in the legislation. It's just that we're preempting the notion that it will be amended and then you amend it later on. But I see no harm in speaking of that committee because it's established by standing order in the actual bill. But it's just that, as I said, we are preempting the fact that it will have to be amended by the members of the committee.
The Standing Finance Committee already exists, so we don't need to create like the Integrity Commission Act was creating a new committee. This Standing Finance Committee already exists, so we can just make reference to it in the bill amending the law that he presents to the Standing Finance Committee of the House of Representatives. So we don't need to amend the standing orders because it already, once we have decided that is the committee that we want to report to, it already exists. It doesn't need to create it. What we're talking about, the dispatch now, is merely an administrative arrangement at the earliest possible or the earliest convenient time for the House to, for the Standing Finance Committee to meet,
I have to say, I would actually really prefer if it was done by way of an amendment to standing orders, which can, and there are two ways to do it, either through standing orders committee or you actually amend it as a consequential amendment in this bill. But I really do think it would be better, a better procedure to actually amend standing orders.
Can we do a consequential amendment to this bill?
You can add it as a schedule, so it has been done before.
A point that Deputy Governor Roper has been making is that recall that this particular provision is relating to the activities of the board and committees. So I'm just highlighting that for the members in terms of the choice of the Standing Finance Committee. It might be relevant, but I just wanted to point out, or we wanted to point out, that this particular section is relating to the report of the boards and the committees.
Yeah, but usually appear before a committee.
Which would not include the Monetary Policy Committee?
Actually, this is speaking about the committees of the board and the committees of the board. Those two committees, the BOJ board, the HR
right, so the
committee,
Monetary Policy Committee actually is not
would not be one of these because the reports from that I think were spoken about before in terms of the minutes, etc. But it's not. No, I'm making a point that it's not a committee of the board. Those are not committees of the board. Those are statutory committees. So the committees of the board would be board committees, HR committee, audit.
So is there a separate reporting other than the publication of the minutes? Is there a separate opportunity for Parliament to interrogate the bank or the governor about the operations of the statutory committees?
Yes, certainly where the Monetary Policies Committee is concerned, the bank has, the governor has to table a report, well, the minister tables a report, and the governor has to appear before Parliament.
Is it the same Standing Finance Committee?
I don't think it was.
We want to just any In any place that the governor appears before Parliament, it should be before the Standing Finance Committee of Parliament. That's what it should. Huh? Yeah.
Yeah, it should be the same thing.
Yeah, it should be this. Yeah, but I thought that when we discussed it, we said that that's what we intend. I don't know if it has to be written in here in that way, but that's certainly the intention that we have discussed. Yeah. Yeah. All right. So we are.
So are we then amending the standing orders in the bill, or you would want this language in the actual?
Amend a consequential amendment of the standing order.
Right.
In the bill.
As a schedule to the bill.
And achieves what I think everybody wants. All right. Thank you. You got that, Secretary? All right.
We have to look it over.
Your committee notes the suggestion made that clause 22 be amended to provide for the inclusion of the contents of the regulation in the form of a schedule to the Act. It was suggested that section 45A, as proposed, be amended to read, the minister may, in consultation with the board, by order, amend the second schedule of this Act, subject to affirmative resolution. Your committee accepts the recommendation. Your committee notes that clause 23 introduces a new section 50A 1 to 3. This provision details enforcement and penalties, and as worded would apply to any contravention of the provisions of the Act. The Act, however, has penalty provisions throughout for breaches of relevant provisions, and the intent of this provision was to be applicable only to the limited governance regulations, having been taken from section 25(1) of the Public Bodies Management and Accountability Act. We note the recommendation from the Bank of Jamaica that section 50A1 should state, if the court is satisfied on an application by the Attorney General that any person has contravened any of the following provisions of the Act or schedules, then insert provisions equivalent to those in the PBMA. The court may exercise any of the powers referred to in subsection 50A2. Your committee accepts the recommendation.
Just to be clear, I'm not sure if this is fully clear, but I think what this is saying is that at that relevant part, then the various sections that are applicable would be inserted in the statute. And so I'm not sure if that is very clear, but that was the intent, that at that section we would put the A to I, which relate to the same points in the PBMA. And there just some typos in there, just a couple. This act, I think, just to match it back with what is in the bill at present. So the only thing that is really being said here is that you'll insert the provisions of the relevant provisions in the PBMA in this section.
Okay. Your committee notes that clause 24A addresses the tenure of board members and the staggering of appointments. The proposed amendment to paragraph of the schedule to the Principal Act provided for a 10-year term of office for appointed directors instead of the current provision for a term not exceeding 3 years. Your committee accepts the recommendation. Your committee notes that clause 24BI addresses amendment of reference made to the Kingston and St. Andrew Municipal Corporation at paragraph 2 of the schedule to the Principal Act. Your committee accepts the recommendation.
Chair, just for this section 2, just to match it back with what is in paragraph 2 of the schedule, the paragraph here should read that your committee notes that clause 24B1 addresses amendment of reference made to the Council of the Kingston and St. Andrew Corporation or of any municipal council or parish council at paragraph 2 of the schedule to the Principal Act, to match it back with what is in there now.
Okay. Your committee notes that clause 24B2 addresses the insertion of a new subparagraph 2D after subparagraph 2C. This insertion excludes persons who are employed with the government, statutory or statutory authority, remove the or, an executive agency or government company. Your committee accepts the recommendation. We note that The new provision addresses the qualification of directors appointed under Section 6.2d and inserts a new paragraph 2a after paragraph 2 regarding the qualification requirements for directors. Your committee accepts the recommendation. The committee notes that the provision of paragraph 3 of the schedule to the Principal Act states that the minister may appoint any person who might be appointed a director to act temporarily in place of a director who is absent or unable to act. The proposal deletes paragraph 3 of the schedule in the Principal Act to ensure consistency with the provisions that removes from the minister the power to appoint directors of the bank, as the same considerations would apply to the appointment of temporary directors. Your committee accepts the recommendation. Your committee notes that the provision of paragraph 4.1 of the schedule to the Principal Act addresses the way in which directors resign. The proposed amendment of paragraph 4.1 of the schedule is the insertion of a new paragraph 1a to provide that on receipt of the instrument of resignation, the minister shall advise the Governor General of the resignation, which takes into account of the new provisions under which the appointment of non-ex officio directors is done by the Governor General in Council. Your committee accepts the recommendation. Your committee notes that this provides an a new clause. Your committee notes that this provides an amendment to paragraph 4.2 of the schedule to the Principal Act, where the governor may resign at any time from offices by instrument in writing addressed to the minister. The proposed amendment is to delete paragraph 2 and substitute, therefore, that the governor and the senior deputy governor may resign in writing to the minister, and the minister should advise the Governor General of such resignation. This takes into account that under the amendment, the senior deputy governor is also appointed by the Governor General in Council. Your committee accepts the recommendation.
Chair, the recommendation we'd like to make, and I think it had been made by Member Golding in his submission that he had made before, is that the proposed amendment is to delete subparagraph 2 and substitute, therefore, that the governor or senior deputy governor may resign. So to replace the word and with or.
Okay.
Replace with or to replace governor deputies and our deputy, senior deputy governor is what you're saying, and or.
Well, it's really, each of them may resign, so it's, I think the point he was making, which I agree with, is that the governor or senior deputy governor may resign in writing to the minister.
Why not and or? Because they both may want to resign too.
And that is true. That is
You're
true.
saying you don't need and, you don't need
no,
or.
you don't need and. Or would capture if they both. Would it? Yes?
And, well, I'll leave it to you drafters. That's way beyond me. Your committee notes that the proposed amendment to paragraph 5 of the schedule allows for the termination of the appointment of the governor and senior deputy governor by the Governor General in Council instead of the minister. It is consistent with other provisions that shifted the authority of appointments to the Governor General in Council. The deputy governors and directors were deleted from the paragraph, as the termination of their appointments would have been covered by Section 5A, Section 6D, and Section 6.6 of the Act. Your committee accepts the recommendation. Your committee notes this.
There are some section numbers that should be corrected here as well. Section 5A should be amended to read Section 6D, bracket 5, capital uppercase A, so 6D 5A. Section 6.6 should be amended to read Section 6.6, capital A, and that's 6.6A, and reference to 6D should be deleted.
Sorry, excuse me. Okay. Can you repeat it for the...
Section 5, lowercase a, should be amended to read Section 6, uppercase D, bracket 5, uppercase A, close bracket. So that would be Section 6D 5A. Section 6.6 should be amended to read Section 6, open bracket 6, uppercase A, close bracket, and reference to Section 6D should be deleted.
Okay, your committee notes this provision seeks to amend paragraph 8 and addresses the remuneration of the governor and other directors, which is determined by the minister. The proposed amendment provided that the remuneration of directors other than the governor and senior deputy governor should be determined by the minister after consultation with the governor. Your committee accepted the recommendation.
Chair, I might have missed it. Did you read a section which I believe says that we also note proposal for paragraph 5B of the schedule to be amended to read becomes bankrupt?
No, I didn't. That's what the secretary here is just pointing out to me.
Oh, right, because I think that's a point that Member Golden had made the last time, which he was wondering whether that section
Yeah, so let me just read it in. It's right. In the. We also note that the proposal for paragraph 5B of the schedule to be amended to read becomes bankrupt. Your committee accepted the recommendation.
Where is that supposed
that is in relation to
bottom of page 33.
Yes, it's in the bottom of page 33, but it relates to the thing about the governor and senior deputy governor, their resignations. So I believe I was 24H, yes. Your committee notes this provision addresses the insertion of a new section, subparagraph 8A, on the appointment of the Audit and Risk Committee and such other committees as the board considered necessary. The committee notes that the provision would be consistent with the provisions of Section 8.2 of the PBMA, which requires the board of a public body that has 4 or more directors to establish an audit committee. We further note that no such provision existed in the Act at that time of discussion. Your committee accepts the recommendation. Now we have consequential amendments to other acts, and before I move into consequential amendments, I should have recognized in the gallery, I believe we have the new resident rep for the fund who has joined these proceedings as a spectator. His name is IMF, of the IMF, Kareem Youssef, and let's welcome him. Kareem has taken great interest to come here and see these proceedings. We note the insertion of a new definition in Section 2 of the Banking Services Act of 2014, which provides a definition of a financial policy committee to include the definition and reference to the fact that it is established under the Bank of Jamaica Act. Your committee accepts the recommendation. Again, under the Banking Services Act, Section 5, we note the renumbering of Section 5 as Section 5, subsection 2, and the insertion of a new Section 5, subsection 1 immediately before to deal with the primary objective of the Supervisory Committee in respect of its supervisory functions. It seeks to include a provision that the primary objective of the Supervisory Committee is the exercise of supervisory functions under the Act and any other enactment. This amendment seeks to satisfy the Basel Core Principle 1, Essential Criterion 2, which provides that the primary objective of the banking supervision is to promote the safety and soundness of banks and the banking system. If the banking supervisor is assigned broader responsibilities, these are subordinate to the primary objective without conflict. Your committee accepts the recommendation. We note that the amendment addresses the functions of the Supervisory Committee and deletes subparagraphs H and M, which relate to financial policy matters, which would now be addressed by the Financial Policy Committee. Your committee accepts the recommendation. We note that the amendment of Section 131, which addresses the making of regulations by the Supervisory Committee in relation to financial policy matters with the approval of the Minister. The proposed amendment substitutes the words Financial Policy Committee for the Supervisory Committee. Your committee accepts the recommendation. Again, Section 132 of the Banking Services Act. We note the amendment of Section 132, which addresses supervisory rules and codes of conduct. It provides that the Supervisory Committee may make rules for the operation of the licensees. The proposed amendment substitutes the words Financial Policy Committee for the Supervisory Committee, as the making of rules for the operation of licensees would now fall under the Financial Policy Committee. Your committee accepts the recommendation. Consequential amendments to the second schedule of the Banking Services Act, paragraph 1. Your committee notes the amendment of paragraph 1, which deals with the composition of the Supervisory Committee. Paragraph 1(3)(a) presently provides that the appointed members of the Supervisory Committee shall not be employed to the bank. The bill seeks to introduce a new subparagraph 3b to provide that the members of the Supervisory Committee shall not be members of the Board of Directors. Paragraph 1(4) presently, can I read this? Presently provides that the appointed members shall be appointed by the Governor General on advice of the Minister after consultation with the Supervisor. The bill also seeks to amend, the bill also seeks to amend the provision that the appointment of members of the Supervisory Committee shall be done by the Governor General in Council, as will be the case of the Monetary Policy Committee and the Financial Policy Committee. The proposed amendment provides for 1. Deleting the word "and" at subparagraph 3a, renumbering subparagraph 3b as subparagraph 3c, and inserting the following as subparagraph 3b. B are not members of the board, and deleting subparagraph 4 and substituting therefore the following. 4. The appointed members shall be appointed by the Governor General in Council. At paragraph 3b, your committee proposes an amendment to read, in quotes, are not to be members of the Board of Directors or statutory committees of the bank as defined by the Bank of Jamaica Act, in order to be consistent with the provisions relating to the Monetary Policy Committee and the Financial Policy Committee.
Chair, for consistency with the definition changes that we had, this paragraph we're suggesting would read, at subparagraph 3b, your committee proposes amendment to read, are not, and you're saying to be members of the Board of Directors or other statutory committee of the bank as defined by the Bank of Jamaica Act, provided that there shall be no more than one member of the committee who is already a member of another statutory committee of the bank, and no member of a statutory committee may be a member of more than 2 statutory committees of the bank, etc., to be consistent with the provisions relating to.
We discussed this at last week's meeting.
So this would be the other provision, the final provision in relation to the point that was made the last time, that what you didn't want is to have a scenario where you excluded a statutory committee member to sit on another statutory committee. And the point, I'm repeating, is therefore that any one statutory committee member can sit on 2 statutory committees. And so this amendment now would be the final one in the series relating to that.
Mr. Chairman, I wasn't here last week, so last meeting, so I hope I'm not going over anything that was covered. But just coming back to paragraph 1, section 132, and just to remind me, the supervisory committee is not a statutory committee?
It is, yes.
It is a statutory committee, okay. So you're here saying in paragraph 1, this is at the bottom of page 36, with the caption paragraph 1. You provide appointed members of the supervisory committee shall not be employed to the bank, and the members of the supervisory committee shall not be members of the board of directors. So just to understand, the deputy supervisor, the governor is the supervisor of the banks. but the deputy supervisor would not be able to be a member of the board.
So member, remember, we're talking about the appointed members, not the ex officios. So the supervisory committee, and I think the others as well, have the ex officio members, and they also have 2 appointed members, each of those committees. And so that's what is being referred to here.
Okay, the appointed members shall not be employed to the bank. The bill seeks to introduce a new subparagraph 3B to provide that members of the supervisory committee shall not be members of the board of directors. That's the sentence I'm referring to.
Yes, so it probably should say appointed members of a supervisory committee. Would that take care of your point?
Yes, because it would seem to conflict with the deputy supervisor being a member of the board of directors. It would seem to prohibit the deputy supervisor.
And the governor.
Right.
So it should say appointed members, good catch. Appointed members of the supervisory committee shall not be members of the board of directors. Okay, I think we're on to paragraph 5, subsection 1, second schedule of the Banking Services Act on tenure of office. Your committee notes that this clause deals with the term of appointment of supervisory committee members. The proposed amendment is to provide that the term of the appointed members shall be 5 years instead of not exceeding 3 years, which is done for consistency with respect to the other statutory committees such as the Monetary Policy Committee and the Financial Policy Committee. Your committee accepts the recommendation. Paragraph 5, subsection 2, second schedule of the Banking Services Act on tenure of office. Your committee notes that this clause deals with the revocation of appointments to the supervisory committee members, to the supervisory committee, it should say. This proposes that the revocation of the appointment of the supervisory committee members shall be by the Governor General in Council instead of the Governor General on the advice of the Minister, consistent with the method of appointment. Consistent with recommendations made with respect to the other committees whose members are appointed by the Governor General in Council, the suggestion is that on the recommendation of the board be added. Your committee accepts the recommendation. Consequential amendment to the Public Bodies Management and Accountability Act, section 5.3, which would represent a deletion, the exercising of borrowing powers. Your committee notes that this provides for the deletion of section 5.3 of the Act, which exempts the Bank of Jamaica from subsection 5.1 regarding the exercise of its borrowing powers in relation to monetary policy. Your committee notes that the bill at clause 3, section 2B, seeks to exempt the bank from the provisions of the PBMA. The exemption at section 5.3 would no longer be necessary if the Bank of Jamaica was generally exempt from the PBMA. The committee would agree to the deletion of section 5.3 on the condition that the issues of the PBMA applicable to the Bank of Jamaica are placed in a regulation that would come into effect with the amended Bank of Jamaica Act.
Chair, could I suggest that instead of regulation, we put schedule just for consistency?
Where?
At the final sentence.
Okay.
Are placed in a
are placed schedule. In a schedule.
Right.
Yeah.
And for the reference paragraph 5, paragraph 5, subsection 1, it should really read subparagraph 1 to be consistent with what is in the bill, and so that there's no confusion. And for the next heading, paragraph 5, subsection 2, second schedule, should read paragraph 5, subparagraph 2.
Mr. Chairman, didn't we agree the what elements of the Public Bodies Management and Accountability Act would be continued to be applicable to the Bank of Jamaica? I think we're way back.
We have circulated here.
Oh, the schedule is circulated?
Yes, the draft schedule.
Okay.
But we have some further changes to make to it, and we're not.
Is that in the same principles of governance one you're referring to?
Yes.
Okay.
These are pulled out the things in the PBMA applicable to the Bank of Jamaica.
And this would be adopted simultaneously with the bill?
It would be a schedule to the bill.
Okay.
Other matter, transitional provision. Your committee noted that transitional provision should also be included in respect of relevant provisions. The idea is that
Is identified?
no, the bill, once a bill comes into effect, without transitional provisions, it means everything in the bill is now law. But by definition.
So I can, for the committee, point out the areas which I think would require transitional provisions to be incorporated in terms of what they would look like. We can talk about that could be talked about. So transition provisions would be required for existing board members and the governor whose appointment terms differ. So currently the board members are appointed for terms not exceeding 3 years. In the new dispensation, it would be appointments for 10 years and staggering. So that begs the question for existing members, what would happen? Would their appointments terminate on the passage of the legislation and a new appointment be done? And so that's the first one.
No.
Yes?
How are we going, sorry, just before you even go into that, in terms of the transitional arrangements, you're saying that we'd have to include them in the bill?
Well, we have the Attorney General and the CPC here, but my observation is that they are usually incorporated in the same legislation because
Right.
what you
So
don't want
Here's
is,
what I would suggest. Here's what I'm going to suggest. I mean, the committee note that the transitional provisions have to be here.
Yes.
When we are going to go over the amendments, then you would share with us the amendments that deal with the transition.
But if we could identify, if it were possible to identify the ones that would apply, would that be appropriate? And then address those there?
Even where you've suggested in the list of amendments that we insert them where you did, where you have instructed, we can't do it like that.
Yes,
So the
understood.
transitional will come at the end of the bill, and these provisions will then.
Right. So what I wanted to highlight, not the where it is placed.
If the committee agrees, yes.
Right.
Chairman, just a concern. If I know, for example, the tenure of the governor would be one such thing. Would that look a little easier to deal with than the board members? Who would then be 10-year? Or would determine the graduation of years of board members if we're transitioning all the board members?
Yeah, that's why I want to have some discussion on it, and I'll come back to you having the benefit of that, if you'd allow me that. Right? Okay, on acknowledgements, your committee wishes to express sincere gratitude to all those individuals and organizations that made written submissions and oral presentations or participated in the deliberations. Your committee wishes to thank the Jamaica Cooperative Credit Union League, the Jamaica Chamber of Commerce, the Jamaica Confederation of Trade Unions, and the Jamaica Securities Dealers Association. I don't see the Jamaica Chamber of Commerce. It's there? The Jamaica Chamber of Commerce, of course, I read it, yeah. A special recognition to the staff of the following entities: the Bank of Jamaica. And we just thank the people who appeared, not the people who submitted, because the PSOJ submitted as well. What is it, how you want to, anyway, I'll leave that up to you. You should have all the people who, thank all the people who submitted. Right? A special, except for people on the committee. Huh? At least acknowledge them, yeah. A special recognition to the staff of the following entities: the Bank of Jamaica, the Office of the Parliamentary Council, the Attorney General's Chambers, and the Solicitor General. I'm just joking. For the technical guidance given to the committee throughout its deliberations. Your committee is grateful to the Governor and staff of the Bank of Jamaica for hosting some of the meetings of the committee and for the very kind courtesies that were extended during those meetings. To the clerk, to the houses, and her staff, a special thank you for the invaluable assistance and courtesies extended during the meetings.
I think you should recognize them, especially for all the weekend meetings we held last December. because of the urgency of this matter.
Why?
I share the view. That's exactly where I was going. I believe
that's not for a response. That's not to provoke a response.
I believe we're understating. We all and pull up the parliamentary staff. We took them on weekends, and so maybe we could just recognize that a little bit more, and not just the per functionary thanks to them. Because they really...
Point taken. Let's emphasize the thanks to the parliamentary staff, for sure.
Well, at least we finished before
this is no ordinary committee.
Christmas.
No ordinary committee. All right, so this concludes the review of the report to the bill. We're going to have an attendance record at the back, which I don't think they have it here yet. There's 11 meetings because it includes this meeting. Huh? Yeah, it will be updated. From here, what we propose is, as I understand it, for the report of the committee to be tabled in Parliament along with the amendments and along with the schedule, which means that we'd have to have a meeting to review the amendments. Is that what we discussed the last time? And amendments consistent with what the report says. I would seek, I don't have a date just yet, but I would seek to have that meeting early in the new year.
So this would be a new draft of the bill, which would reflect the amendments?
No, we just have the list of amendments first.
Okay.
Just a list of amendments.
But to make it easier for the average parliamentarian who has not participated in the committee, and even for those who
make it the bill, no, it's going to be, huh?
No. What we would have is the amendments to the bill. Any parliamentarian who should have been here or who is going to see the new bill would have to wait until the new bill.
Wait on the new bill, member. We can't. What we know, we know the amendments we agreed. Once you get into the putting it into the bill.
Okay, so
it's like doing another review.
Assuming that the Parliament accepts the report and the recommendations of the committee, they will then have the new bill drafted. So we just do it as a two-phase.
They will have the new bill, correct. But we want to first, But you
will be appending a list of amendments to the report. So outside of that, if you want to have a brand new bill, you'd have to withdraw your old bill and table the new bill.
Yeah.
Not for this committee. Not for this committee.
But in any case, once you have a report, you append the list of amendments to the report.
That's my understanding.
Right. But moving beyond the report, I'm just saying, if we're going report, we'll just have the amendments, and if you're then going to have a debate, there are so many amendments that it would be just convenient.
Agreed, and so
to withdraw the bill
that has happened before, and what you have to do is withdraw the bill
and table a new bill with the amendments coming from it.
Well, yes, you would now incorporate, so you'd have a brand new bill that you table.
Yeah.
Let's go through the amendments first. I mean, I think you do it if the amendments are substantial, which they appear to be in this case. You see more.
Just to identify the other changes that are being proposed for these setups.
So when they're made, you'll get an updated copy of the schedule. All right, so I'd seek the corporation of members to have those meetings early in the new year. I'm looking at Lord, somebody has taken over the parliament. This committee. No, you can't do this, man. OSHA, every day, you can't do this. They can't do that.
Leslie?
Who is the chairman of this committee?
Leslie
Huh?
is the chairman.
Huh? But they're taking every available day in January. There's one available on the 22nd, but I don't even know if that's retreat. I don't know. All right, we're going to have to set the date outside of here. I'm going to they could give us one. They have 1, 2, 3, 4, 5, 6, 7, 8, 9 in January.
Minister, they're looking at extra one. They're looking at extra day. OSHA is looking at extra days, so the 9 is not even sufficient for them.
You see the problem with our little parliament?
No, the problem is that OSHA affect the safety of workers affect
No,
everything.
it's important. But the point, we should be able to have 2 committee meetings, you know, at the same time.
Except you have 3 people in that committee right here.
From here.
Yeah. And that's usually what makes up your quorum. Sitting in the same room.
The practical problems of a small country.
Sorry, Chairman, there would also be another issue if you had more than one committee meeting at the same time.
The staff.
Okay.
Yeah. All right, but it's not so. It's the fact that they've taken every available day. But we will resolve that outside of here. We will resolve that outside of here. It remains for me to ask if there's any other business and ask your for your understanding that the date of the next meeting is set after some consultations. Thank you all very much. Thank you.